Good morning, this is your Kelso Report for Monday, April 9th, and I'm your host, Clark Kelso. It was a light Friday, so we have only 3 cases. The Ninth Circuit certified a couple of questions to the Nevada Supreme Court, decided a criminal law case, and we have a juvenile law matter from the California Court of Appeal. We'll begin with the Ninth Circuit, of course, with its certified question in an insurance coverage action. In Century Surety Company versus Casino West, the Ninth Circuit certified 2 questions to the Supreme Court of Nevada. The first question is, does the pollution exclusion in Century's insurance policy exclude coverage of claims arising from carbon monoxide exposure? The second question is, does the indoor air quality exclusion in Century's insurance policy exclude coverage of claims arising from carbon monoxide exposure? These questions arose in the context of a tragedy at one of the Casino West properties, the Casino West Motel. 4 individuals died while staying in a room at the motel. The coroner determined that the deceased individuals died of acute carbon monoxide poisoning. Apparently, carbon monoxide fumes from the motel's pool heater room had permeated into the deceased individual's room because the air intake openings had been blocked. So, we'll get to see whether the Nevada Supreme Court thinks the insurance policy's pollution and indoor air exclusion covers this particular scenario. Next, we have a criminal law case involving the sale of contraband cigarettes. The defendants in United States v. Wilbur were indicted for an 8-year conspiracy to violate the Contraband Cigarette Trafficking Act by trafficking in contraband cigarettes. Now, contraband cigarettes, as defined in relevant part, are cigarettes which bear no evidence of the payment of applicable state or local cigarette taxes in the state or locality where such cigarettes are found. That's Title 18, Section 2341. The defendants moved to quash the indictment on the ground that their sales were pursuant to a license issued by the Swinomish tribe and were therefore not subject to state or local cigarette taxes. The district court refused to quash, and the defendants then pled guilty. Well, on appeal, the Ninth Circuit held that the motion to quash should have been granted with respect to the years 2003, 4, and 5, and that the applicable 5-year statute of limitation barred any action based on sales from 1999 to 2003. This still left the defendants with violating the CCTA for the years 2006 and 7, and the court remanded for further proceedings. The California Court of Appeal in a dependency proceeding, the juvenile in re BL, had previously been subject of a dependency case which resulted in the paternal grandparents being appointed as BL's guardians. A second dependency proceeding was commenced when it turned out the grandparents had misrepresented to the Human Services Agency that they would conduct supervised visitation with the parents. But actually, the grandparents had simply turned BLO over to the parents. When the parents then were rearrested on drug charges, this misrepresentation came to light, and the second dependency proceeding began. Now, the parents in the second proceeding claimed a right to reunification services, but the 4th District held the Superior Court had correctly denied reunification services to the parents since, having previously had their parental rights terminated, the parents were not entitled to reunification services under the statute. The court did remove the child from the paternal grandparents, but granted them reunification services, which the 4th District said was exactly the right thing to do in the circumstances. We'll see if another relative can do better than the grandparents. That's it for today's Kelso Report. Have a great day in the law.